There was an issue with the plaintiff getting off of state assistance. He's continued to pay $2,300 a month, even though the agreement was to reduce it to $2,000 a month.
Single mom, single-handedly raising the child. The father has zero involvement.
I have never had an issue with the $2,000.
Matter of Masterson, now Andreessen versus Yardley, case number 1C. Mr. Hess, I've read your motion. Is there something that you'd like to add to it?
No, I think the issue is pretty simple. There's been a long delay since we reached this agreement through email, which I certainly think is binding under the court rule. MCR 2.507G. We had done lump sum payments in the past outside of the front of the court, but there was an issue with the plaintiff getting off of state assistance. And so we just really need this order entered. It's been just a long delay. So we're just asking that this order be entered.
And the longer the delay is, the more problematic it gets, because this order goes back to only May 1st of 2023. Yeah, if there's a 2-month arrearage, the federal reporting agencies reported on your credit rating, so it didn't get credit.
The problem is my client has actually paid the old amount through the front of the court. So he's continued to pay $2,300 a month, even though the agreement was to reduce it to $2,000 a month. So that's why in the UCSO, I put that he will pay $1,700 a month until his overpayment is corrected.
I think $1,700 a month is what the front of the court recommended after their investigation. So, Ms. Forsyth, what is your input on this? I didn't get a response.
Well, because I'm sitting in here with Ms. Andreasen as a professional courtesy. She has been represented by Connie Thacker until...
Correct.
Here we go again, with another courtroom stuck in slow motion, where a simple child support adjustment turned into a year-long maze. Everyone agrees on $2,000, but somehow the paperwork just vanished into the void. The dad keeps paying too much. The mom keeps waiting. The lawyers keep talking. And the judge looks like they have heard this story 100 times before. It is like watching a rerun of Bureaucracy on Repeat, where logic checked out months ago. But the conversation keeps going, on and on, as if confusion was part of the process.
Probably yesterday or the day before, when Connie withdrew, Ms. Andreasen intends to, if need be, to retain Wade McConnell to represent her.
Okay.
But this is all, I had asked Mr. Hess if he would adjourn the motion a couple weeks, but he won't.
This has been pending for over a year. Why would he adjourn?
Well,
we need an answer here, and he attached the emails. This is an agreement between parties.
Well, here's again. I'm not. I haven't.
I know you're sitting in, but Ms. Forsyth, she may represent Wade McConnell, but I don't think I have a choice under the court rule. I've got evidence that this is the agreement. This was the agreement last April. It has now taken a year to get this in place, and it needs to be put in place. So I'm going to follow the agreement of the parties. I am going to grant the entry of this child support order just to move this along. If she would like to object to it using Wade McConnell, they'll have to explain to the judge why the court rules do not apply.
Yeah, no, I understand. I guess the one thing we would ask, and Cindy, please interject, because I obviously don't really know the background here. All I know is, I did speak with Cindy yesterday, and she has no issue with the $2,000 a month. She said she actually never even got that. She's fine with that. Her issue is, here we have the single mom single-handedly raising the child. The father has zero involvement. Our issue is to still make her pay the money back.
No, it's not being paid back. It's backdated, and that's why the child support is reduced until it comes to zero. If there's an arrearage, he would have had to pay it. If there's an overpayment, then it has to be, the child support is reduced, and it's only being reduced by $300 a month. And since he's agreeing to pay almost $3,000 more than what the child support guidelines indicate, she's not coming off much worse for the wear.
The lawyer stands there explaining numbers like, it is rocket science, but all it means is someone overpaid and wants it fixed, while another lawyer tries to hit pause, pretending a few more weeks will change anything. The judge has had enough, and just wants this order signed already. It feels like watching someone argue with a calculator that only speaks legal code. Everyone nods, but no one moves, and the clock keeps ticking. The whole room screams agreement. Yet somehow, nothing ever gets done until the judge swings the hammer of common sense.
Cindy, do you want to throw in your 2 cents here? Because you obviously know the background here, and I don't.
I completely agree with Dan Hess and that this can has been kicked down the road. I have never had an issue with the $2,000.
Okay.
I put something in writing in February stating, to Connie's office, yes, I'm still on board. Let's proceed forward. I have no issues with this.
Okay.
A month later, she called me and said, okay, where are we at? And I said, my position hasn't changed. I'm aligned with the 2,000 per month.
Right.
We all agreed on that. And she said, are you receiving support at this time? I said, I am. In fact, I'm receiving $2,300 a month. And she said to me, my advice to you is to sit back and leave it if you're getting the $2,300 a month.
Well, and there's a consequence to that because he's
Understood.
overpaid. But yeah, and asking for the amount to be reduced by $300 until that amount is made up, then it will jump to because technically it's the 2,000. It's just lowered by a monthly amount until the offset is made to zero, and then it goes to the back. It's going to be at the 2,000.
Okay. So I'm completely aligned with the 2,000. Nothing from Attorney Thacker has ever been presented to me.
Okay.
Multiple emails I followed up with her to say, where are we at? Like, I feel like we're kicking the can here. So much so that, even last week, I got the motion sent to me out of the blue, and I said, why is there a motion? Like, who's fighting? I'm aligned. Let's go.
So it's not a fight, and I'm going to agree with you, Paul. All I'm going to just enter this.
The one thing, referee, that I wanted to bring to attention, I'm in the process of negotiating a new job offer, which was the reason that I requested.
Your pay is irrelevant to this. Okay, to explain it mathematically.
Now the mom finally gets her. Say calm, polite, but clearly tired of the endless loop, she says, yes, I am fine with 2,000. Yes, I said that months ago. And still we are here. The dad has been paying extra. The court has been. Sitting still. And patience ran out somewhere around paragraph 20. Everyone pretends to be shocked, but it is really just paperwork drama, dressed as a legal mystery. Even the judge seems ready to shout, let us just sign and go home before another. Motion appears out of thin air.
He is set at 0 overnights. What the guidelines do is they calculate how much you would pay him if he had full custody, and it calculates how much he would pay you if you had full custody. Then it offsets using the parenting time.
Sure.
And normally 0 to 70 doesn't do much, or I should say 1 to 70 does very minimal changes because they don't want people arguing over every other weekend, sometime during the summer and every other holiday. But anything times 0 is 0. So there is no offset by your salary. Okay. I could cut your salary in half. I could double your salary. Anything, again, times 0 is it. So this is based 99.99% on his income only.
Okay, that makes sense. Child care expenses will be a large portion of this, which is why I was hoping to not waste the court's time now. And then once I have the job offer in place and I'm paying childcare. She's 8 years old. Summer started last Friday. There's going to be.
This is going to have to be reassessed due to daycare.
Yeah, the costs.
Okay.
I know. Well, I tried to call attorney twice. I wrote a note to your clerk.
All right. So how daycare is calculated by the program will take how much you pay during a year, or how, so in other words, if you only pay for the 3 months of summer, it gets divided out by 12 months. So you may pay, let's say, $300 a week for 8 weeks. That's $2,400. That's $200 a month.
Okay.
But it then also takes out your tax break on that. So if you get the full tax break, because you're not paying more than what the tax break used to be, $2,400 per child. So you there may be no daycare.
And just when you think it is over, someone brings up new job offers and salary math. Like this is a courtroom version of algebra for beginners. The judge jumps in, explaining 0 times. Anything is still 0. So stop worrying about income that does not even matter. The lesson today is math beats arguments every time. This is not about new jobs, it is about overdue signatures. You can almost feel the collective sigh of the entire courtroom as everyone realizes this could all have ended months ago if common sense was allowed to testify.
So you may want that calculated first. Okay?
Yeah.
And understand, like I said, the calculation said that he'd only pay $1,700. You throw daycare in there and it throws out this agreement. So it may come into exactly where you're at. Talk to an attorney. All right, just in case. I'm just trying to help
Sure,
and explain
appreciate that.
I'm trying to also explain to the attorneys because sometimes the nuances, which I see frequently, they don't. So, and sometimes I have a lot of attorneys that are arguing over nickel and dimes.
No, I understand.
And you're getting more in attorney fees than you're going to pay than nickel and dimes that are going to occur to the changes. So make sure you know what you're asking for before you ask for it. Mr. Hess, I'm going to grant your order and I'm going to set this in place. Okay?
All right. Thank you, Your Honor.
Thank you. And Ms. LeVay, I've got the UCSO here signed. I'll need my signature sheet for the back of it.
Do you need me to present you with anything further?
Nope. I think the UCSO modification is appropriate.
Okay. All right. Thank you, Your Honor.
All right. You take care. All right.
Yep, you too.
All right. Bye, guys. Have a good weekend. Take care.
Nice seeing everybody. Take care.
Andrea.
Okay.
The final stretch brings a masterclass in daycare economics, where the judge calculates like an accountant on caffeine, breaking down weeks, months, and tax breaks until everyone silently regrets asking the question. And yet through the chaos, a little clarity appears. The numbers line up, the confusion fades, and the order finally gets approved after a year of circling the same drain. It ends not with a dramatic twist, but with everyone quietly agreeing that maybe, just maybe, signing the paper sooner would have saved 9 months of pure courtroom comedy. Thanks for watching. Hit like, share, and subscribe. Stay tuned. The next wild case is coming fast. See you there.